Hello and a very warm welcome to World This Week by Latest Laws. This is our weekly program, so subscribe and press the bell icon to get notified. My name is Monica Rahar and let's get started by having a look at Supreme Court this week. The first update that we have, it is with respect to defining the ambit of Proviso 6 of Section 92 of the Indian Evidence Act. So, a three-judge bench of the Honorable Apex Court has observed that it is manifest from Section 95 and Proviso 6 of Section 92 of the Indian Evidence Act that it is only in cases where the terms of the document leave the question in doubt that this particular proviso can be resorted to. But when the document itself is straightforward, it is unambiguous, and it does not present any difficulty in construing it, then the proviso does not apply. The bench further held that Section 95 only builds on Proviso 6 of Section 92. Now we need to understand Section 92 bars giving oral evidence with respect to the contents of a written document. However, Proviso 6, it allows the admission of facts external to the document, which shows in what manner the language of a document it is related to the existing facts. Next, we have an update in the Bhima Koregaon violence case. So, the Apex Court dismissed a petition filed by Gautam Navlaka, who is an accused in the Bhima Koregaon violence case. This petition, it challenged the Bombay High Court order rejecting his plea for default bail. A CJI-led bench of the top court has, in the case of Sanjay Kumar Rai vs. State of UP, observed that orders framing charge or denying discharge, they are not interlocutory or final, and therefore they are not affected by the bar imposed by subsection 2 of Section 397 of Code of Criminal Procedure. Hitesh Dev Sharma is the coordinator for the National Register of Citizens in Assam, also popularly known as the NRC of Assam. He has filed an application in the top court seeking a complete, comprehensive and time-bound re-verification of the updated draft as well as of the supplementary list of NRC, citing glaring defects of serious nature which were detected in the process. A division bench of the top court, which was issuing a slew of directions relating to migrant workers who are stranded in NCR due to the COVID-19 lockdown, has ordered the governments of Delhi, Haryana and UP to provide dry ration, open community kitchens and ensure transportation which is proper for those who are desiring to return to their home districts. Now let's proceed to the next segment of our news analysis and have a look at the Delhi High Court this week. A single-judge bench of the Honorable High Court of Delhi has, in the case of Shifa-ur-Rahman vs. NCT of Delhi, observed that the right of a person in detention to consult a legal practitioner of his own choice, it is a constitutionally guaranteed right, and therefore it is not open for the state to dilute this right on the ground that no purpose would have been served even if such consultation was permitted. The Delhi High Court on Thursday, comprising of a single-judge bench of Justice Anup J. Bhambani, stating that there is little else that can be done apart from prosecuting the offender and that it cannot undo the offence, awarded ₹6 lakh as interim compensation to a minor victim of sexual assault. The High Court has refused to provide interim protection from arrest to Navneet Kalra, who is the owner of Khan Chacha restaurant in Delhi, in the case regarding the alleged black marketing of oxygen concentrators. The bench also posted the matter for further hearing on May 18 after Additional Solicitor General S.V. Raju, who is appearing for the Delhi Police, saw time to file reply and argue in this matter. Indicating its displeasure with the centre on the vaccination situation while stressing on the need for innovative dissemination of COVID information, during a hearing on Thursday, the High Court remarked, and I quote, "What is the point of this irritating caller tune when there aren't any vaccines available?" Now let's proceed to the next segment of our news analysis and have a look at the Bombay High Court this week. The Bombay High Court recently has set aside the bail condition of depositing ₹22 lakh imposed on an accused in a fraud case by Additional Sessions Judge on the grounds that such an enormous condition for bail, it wasn't maintainable. As 3 other accused in the fraud case had already been granted bail, the High Court granted bail to the accused on grounds of parity while imposing the condition which are applicable in normal bails. The Maharashtra government has stated before the High Court that Parambir Singh, who is the former Mumbai Police Commissioner, he will not be arrested till May 20 in connection with an FIR which was registered on a complaint of one of the police officers. So the FIR against Singh and about 30 others, it was registered on April 28 under the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act, apart from sections under the IPC for criminal conspiracy and for destruction of evidence. Along with that, Section 7 of the Civil Rights Protection Act of 1955, it was also invoked. The incidents in the FIR, they took place in the year 2015. The High Court in a case has stated that doctors and healthcare staff who are, quote-unquote, in the front line and working tirelessly during the COVID-19 crisis, they are required to be protected by the authorities from assault by relatives of patients. Now the next segment that we have, it is of Madras High Court. A single-judge bench of the High Court of Madras, comprising of Justice M. Nirmal Kumar, has observed in the case of Mesos Trans-Pacific Logistics Private Limited versus the Commissioner of Police and others, that a civil dispute has to be adjudicated between the parties before a civil court and that the police has no role to play in it. In a case pertaining to issuance of a passport, another single-judge bench of the Madras High Court in the case which is titled as Nagalingam versus the Regional Passport Officer and others observed that an FIR will not be construed as criminal proceeding until the final report is submitted by the police. Now let's proceed with the miscellaneous segment of our news analysis. A special court constituted under the Fugitive Economic Offenders Act has issued a public notice to fugitive diamond merchant Nirav Modi, who is wanted in India for alleged fraud and money laundering in the PNB scam case. The court has asked Modi as to why his property should not be confiscated under the Fugitive Economic Offenders Act. He has also been asked to be present before the court on June 11. Now we need to know that Nirav Modi, he was declared a fugitive economic offender in the year 2019 on a plea of the Enforcement Directorate, which is currently conducting a probe in this matter. An alleged Al-Qaeda member who is a doctor and who is lodged in Tihar jail, he moved a Delhi court seeking permission to assist the prison authorities to deal with the COVID-19 crisis. In his application before the court, the accused submitted that his experience and expertise as a medical professional, it would be helpful in dealing with the surge in COVID-19 cases and in treatment of inmates in the central jail. On Friday, the Delhi High Court issued a notification announcing the preponement of summer vacations of the Delhi district courts in view of the second wave of COVID-19. The vacation is to last from 17th May to 3rd of June 2021. Now let's proceed with the last segment of our news analysis, which is the international news. On Friday, Ireland's High Court rejected a Facebook bid to block an inquiry by the Irish data regulator that could halt Facebook's data flow from the European Union to the United States. The judgment said, and I quote, FBI has not been able to establish any basis for impugning the DPC's decision or the PDD, which is the preliminary draft decision or the procedure for the inquiry adopted by the DPC. Now, DPC here stands for the Data Protection Commissioner. On Friday, the Mississippi Supreme Court struck down a medical marijuana initiative that was approved by voters in November. In a 6-3 ruling, the state's High Court held that medical marijuana initiative that was passed with 73% of votes in November, it had to be struck down because of an odd defect in the state constitution's voter initiative process. On Monday, a judge ordered Myanmar's former leader Aung San Suu Kyi to appear in person in court for the very first time on May 24 after she was detained on February 1 after a military coup. That's all we have for this week. In case you need more information with respect to any of these news stories, you may refer to the description section. And thank you for being with us.